Are you thinking about making some fat cash in the booming THCa hemp industry?
This video is for you. In today's episode, we're delving into the fascinating and complex
Aspect of cannabis legislation.
the legal status of THCa hemp. You are seeing it all over the internet, available for sale in all 50 states. At a few clicks of the button online, or at your local smoke shops and even gas stations. You may not know that THCa hemp occupies a unique position in the legal framework, especially when it undergoes a transformation into marijuana, but it gets just a little bit too close to a flame. Let's unravel this intriguing subject and why this purportedly legal hemp product is becoming a bestseller nationwide. First off, what exactly is THCa hemp? It's a form of hemp that contains tetrahydrocannabinolic acid, THCa, a non-psychoactive precursor to delta-9 THC, the main psychoactive component in marijuana. Federally, THCa hemp is legal, falling under the legal definition of hemp, which is why any cannabis with a delta-9 THC concentration of not more than 0.3% on a dry weight basis is legally hemp. Here are the key points to remember about THCa flower. THCa hemp is a legally distinct thing from marijuana due to its low delta-9 THC content. In its raw form, it's non-psychoactive and federally legal under the 2018 Farm Bill. The complexity arises when THCa is converted into delta-9 THC, typically through heating or burning. That's right, THCa hemp is legal unless it's lit on fire. Then the THCa decarbs or decarboxylates into delta-9 THC. That is still recognized as marijuana under federal law. Still a Schedule I substance as of today, December 21st, 2023. Now, this decarb happens once the THC hemp passes around 240 degrees or 137 C, which is far below the 440 degrees or 225 Celsius or more that the end of your joint burns at. So that means that THCa is legally hemp, unless it is smoked or heated. It is actually and factually hemp under the express terms of the federal law defining hemp. Hemp farmers can even legally grow it compliantly with the USDA testing requirements. You see, the final rule specified pre-harvest samples shall be approximately 5 to 8 inches from the main stem. That includes leaves and flowers, the terminal bud that occurs at the end of the stem or central cola, a cut of the stem that could develop into the top bud of the flowering plant. According to Section 990.24 of the federal rule for the USDA hemp farms, responsibility of a USDA licensee prior to harvest, no more than 30 days prior to the anticipated harvest of the cannabis plants, a sample agent shall collect samples from that plant and test it for total THC, which is delta-9 THC plus the THCa concentrations, and then they do some math. I believe they multiply it by 0.877. If you're watching this channel, probably know that a flowering cycle takes about 8 weeks. So when your plants are about 4 weeks in, they have to be tested for total THC. Most THC production occurs within the last 4 weeks of flower, with up to 40% of it happening in just the last 2 weeks. That's just the last 14 days before harvest. But the USDA rule for hemp says that you only have to test it no more than 30 days beforehand. So you can test it, then do all the tricks in the book to boost THC production after it is legally compliant hemp. But what about selling it, like in a pre-roll, where you know the person is going to smoke it? That's not illegal until it is lit on fire. So are you helping to facilitate a crime? If you own a hemp shop or a gas station and you're selling THCa hemp, is that without any legal risk? Or is it aiding and abetting cannabis trafficking? Or does some state law say that you can't do it unless you have a license? Let's take it one step at a time. Aiding and abetting is like if you drive the getaway car after somebody else robs the bank. But selling a THCa pre-roll is more like the Uber driver dropping the robbers off to their own devices. It was a perfectly legal transaction. After that, they committed a crime. But you still knew it. You knew that the buyers wanted to smoke it and turn it into marijuana. So maybe the THCa market is a vast criminal conspiracy to distribute, which literally is an unscheduled agricultural commodity nationwide, with the intention of having it all go up in a series of small fires and be converted into tons of marijuana. That raises a question of how can it be a conspiracy to distribute an unscheduled agricultural commodity? A conspiracy is an agreement between two or more people to commit an illegal act. So provided that the seller of the hemp does not agree for you to light it on fire, then it's not a conspiracy. But what if the clerk at the shop asks if you need a lighter and says that they sell them? Well, maybe now we're getting into some conspiracy. But wait a minute, what about all those licensed marijuana shops all over the United States? That is an overt conspiracy to traffic a Schedule I drug, and no enforcement has happened. So what is more likely to be interfered with? Lawful actors or unlawful ones sanctioned with a state license? That legal question remains unexplained.
So prepare yourself for the unimaginable, the unknown, and the unexplained.
It remains legal for the seller of the THCa hemp under federal law and for the people to buy it without any age restrictions at the federal level. They can buy it and they can do with it what they will, hopefully in the privacy of their own homes. Then it's none of your business. We'll see, but isn't that unfair then in illegal states with criminal penalties for marijuana? You can basically sell it so long as it's hemp until you use it as directed? Right now, if you legally buy a THCa pre-roll in Tennessee, Texas, North Carolina, for example, and use it as directed by lighting it on fire, well, that's a crime in those states because it is magically transformed from an unscheduled agricultural commodity into a Schedule I substance. But what happens when that rescheduling rule comes into effect from the Biden administration's executive order and the HHS letter telling the DEA to move cannabis to Schedule III? That's different. Now you will have a legitimate defense. It was an agricultural commodity that turned into a recognized medicine, which you may be using without a prescription. However, back in the day, back so long ago that they would call it old school, like in the 90s, after Prop 215 in California,
we passed 3 bills 3 years in a row with bipartisan Republican and Democratic support, only to be vetoed by Governor Wilson. Frustrated, we combined those 3 bills into one initiative and set about collecting 850,000 signatures to put a proposition on the ballot that will legalize marijuana as a medicine.
People caught with simple possession of cannabis tried to get their medical card and use it was a medical use defense at their court date. Now, we're going to be doing a whole video about Schedule III and trigger laws that make medicine out of cannabis nationwide when it's rescheduled. What will happen when THCa hemp becomes Schedule III thus far is unexplained. However, as it stays a Schedule I drug and remains criminalized in many states, decriminalization of simple possessions of a low amount of cannabis has never been more important. And you should check your state laws to see if possessions of a small amount of cannabis has been decriminalized before you consider trying THCa hemp. With the complex nature of THCa hemp and marijuana's current legal status, aiding and abetting and conspiracy laws become even more critical to understand. If you're involved in activities that may result in the conversion of THCa hemp into Delta-9 THC, you could face legal consequences. For example, what about providing equipment, offering tools or devices to facilitate the transformation of THCa into Delta-9 THC, or transportation and distributing? What if you're transporting or distributing THCa hemp for the purpose of its conversion into Delta-9 THC? Without knowledge and intent, being aware that the THC hemp will be converted and intentionally aiding and abetting that process by offering customers a light. In summary, THCa hemp is a unique legal concept in America that is completely legalized unless it's lit on fire. Then it is completely banned, at least at the federal level. While it starts as a federally legal substance, its transformation into Delta-9 THC under certain conditions can lead to significant legal risks, especially aiding and abetting and perhaps conspiracy laws. So stay informed about the current laws and regulations regarding THCa hemp in your state. If you're involved in any aspect of the THCa hemp industry, consider consulting with a legal professional to get an opinion on the lawfulness of your actions. Remember, the cannabis legal landscape is complex and ever-changing. Seeking appropriate legal advice is one of the best tools in navigating those waters. Thanks for joining us on this episode. If you liked this video and it provided valuable insights, please give us a thumbs up and subscribe for more content on cannabis laws. If you have any questions about THCa hemp, drop them below in the comments. We'd love to hear from you. Stay informed and navigate these legal intricacies with confidence, or at least caution.